Welcome and thank you for joining us today for Control's complimentary webinar, How Long to Save Chats, Messages, Recordings, Prompts, Emails, and Other Odds and Ends. We'll begin the webinar shortly. Hello, and thank you again for joining us for today's complimentary Control webinar, How Long to Save Chats, Messages, Recordings, Prompts, Emails, and Other Odds and Ends. Today, for some housekeeping items, I wanted to note that the event will be recorded. This recording will be shared with you via email tomorrow. At the end of today's presentation, we'll show you a list of upcoming complimentary webinars and events. If any of your colleagues are interested in joining future sessions, please visit us at control.com and select the Events tab to register. We'll also share white papers, blog posts, articles, and anything we've recently posted. Also, I encourage you to please participate in our post-event survey. We invite you to complete this feedback as we really value and appreciate any comments you have. If you have follow-up questions or comments, please feel free to reach out to us. Thank you. And now I will introduce Tom Mile, COO of Control, as well as Mark Diamond, CEO and President of Control. Thank you.
Thank you. Thank you, Veronica. Today we're going to talk about chats, emails, and messages, recordings, prompts, odds and ends. You know, this is a very perplexing part of records management, information governance, data retention, and what the right strategy is, because it's a lot of new and different stuff out there. I'm Mark Diamond. I'm CEO of Control. I got the easy job today. I'm going to be moderator. I'm going to be asking the questions, and really our featured presenter today is Tom Mile. Tom, you want to introduce yourself?
Hi, everybody. I'm Tom Mile. I'm Chief Operating Officer at Control. I've been with Control for about 15 years. I run the delivery team and work a lot with organizations on these particular issues.
Thank you very much. So just a reminder, Control is an independent provider. We're going to talk about different products and technologies today, not because we sell them, because we don't, not because we take referral fees, because we don't. just because we have lots of clients that use lots of different technologies, and we develop an opinion on what works and what doesn't work. But rest assured, we're not giving the opinion because we're trying to sell you something. Again, we're completely independent, and so our advice today is just our opinions on this. Okay, let's just jump into that. And it seems like the stuff we have to potentially manage is getting more complicated. I mean, it's not just paper or email anymore, paper or files anymore. There's a lot of other stuff out there.
It's true. I mean, even just 5 years ago, the big question was, and frankly, we're still getting this question today, how long do we keep email? Today, I would argue that email is the grandfather of communication tools, and it's just one of many, many ways that employees are communicating or collaborating with each other. Some surveys have shown that organizations, on average, are using very technical 3.3 different messaging apps, and employees are splitting their time across these platforms. I think whatever that number happens to be, we're seeing this a lot, that organizations are using more than one tool or application or platform to communicate with each other. And there are retention issues that come up with it. You know, for example, Slack and Teams, those are now the digital hallways. That's where conversations happen. But the difference in the line between a casual chat and a contract negotiation in one of those tools can be very thin. We're seeing a huge increase in what we would call ephemeral and encrypted messaging, Signal, WhatsApp, Telegram. They're becoming common, really, even in business settings, sometimes without company knowledge or approval. The regulators are actually already cracking down in financial services on some of these areas. So something that the regulators are paying attention to, so you need to be paying attention to. Zoom and team recordings exploding. People are wanting to record meetings all the time, use the AI tools to do transcripts and figure out what to do after the meeting. Some companies keep them by default forever without even knowing about it. But few are actually asking, are these records? How long do we need to keep them? Now we add in generative AI. Prompts and outputs are brand new forms of communications that can contain sensitive information, they can contain decisions, they can contain intellectual property, and they're not being captured in most retention programs. So we're going to talk about that. The problem here is really the volume. The problem is that the formats are fragmented. They're all over the place. Some of them are transient. They may not last forever, and they're all challenging to classify. So that makes them easy to forget about, but it's also easy for regulators and courts to question because they're out there and they're already questioning it. So we want to talk about it. We think it's important to talk about developing some good principles for retention during this webinar.
Tom, some of these are under the purview, or maybe I should use a different word, or under the guidance or control of IT, but some of these aren't.
Well, and it depends. There are some organizations that, you're right, things like WhatsApp, there might be tools like Signal or Telegram. They tend to be more in the ephemeral app place where we see unapproved things happening. But as we'll talk in a minute, we had one organization that found that they had so many more tools that were being used. It really depends on how you've organized and how your IT department operates. There are some companies that have a more permissive culture with regard to allowing these types of applications, and that leads to an explosion of information.
All right.
So
now, I'm sorry, go on, Tom.
No, go ahead.
I was just going to ask, well, actually, perfect setup. Some people are saying, hey, this stuff is not real. I mean, WhatsApp, that's not something that we have to worry about, or so ask the question, do all of these matter, and how do we look at whether these are real records or not real records, or they matter or don't matter?
And I think, and we're going to kind of dive into this more deeply on each kind of level of the different types of messaging tools we're going to talk about. The answer is it depends. They could be records. You could choose to say that they aren't records. There will be pros and cons to each of those approaches. So let's walk through that. Let's talk about kind of why they might be records, why you might want to decide that you don't want to include them or prohibit them. And there might be different approaches to each one of these. There's not going to be an easy standard answer for all of them, but there will be some standard principles to follow that I'm going to be hammering on those during the course of the next hour. So here's why they matter. So that if you're ignoring things, you're risking having compliance blind spots. We're going to discuss shortly, the SEC is already fining financial firms of billions of dollars for not capturing business communications from certain messaging apps. From a litigation standpoint, failing to include these formats in preservation or on legal holds can lead to sanctions if you can't produce them, or even at a minimum, lack of credibility, loss of credibility if you're not able to produce them. Privacy laws push the other way. They don't want you holding on to personal or sensitive data forever. And a lot of these messaging apps have that information. So keeping recordings of every meeting indefinitely is a privacy and time bomb. So it's something you're trying to figure out, how do we strike a good balance here? There's also the issue of cost. Uncontrolled retention is going to drive cost. Cloud storage seems cheap until you multiply petabytes of unneeded data and the cost of discovery review if it turns out to be relevant to some litigation or regulatory investigation. Now, on the positive side, if you're managing it, having rules that cover these odds and ends makes your entire retention program more consistent and more defensible. It's going to show regulators we're serious about governance. We know we keep these communications. We've made the decision to look at these communications, and here are our policies for each one of them. It's also helping employees to be managing them appropriately. Without clear rules, most of the clients that we work with, the employees tend to be rule followers. They're not mavericks. They're not out there doing things. They want to follow the rules. Without clear rules, employees will do one of two things. They're either going to save everything, and that's usually the default. To be safe, I'm going to keep everything forever. Or if they're not, they're going to delete it kind of ad hoc, haphazardly, without any rules. Either way, that's putting the company at risk. One example of a client that we had is that an organization, one client, they began conducting all of their HR performance reviews on Zoom. And those meetings were recorded by default. Now, Zoom had a default retention period for recordings. HR didn't realize that IT had actually changed this setting, so all video recordings had indefinite retention. It usually has a much shorter period of time, but that meant that all of these HR performance review recordings were being kept permanently because they had made that setting at the request of corporate leadership who wanted to keep board and other important meetings permanently. Once they realized what they were keeping, they had to change that policy because they were keeping a lot of personal information permanently. But they also needed to keep those important meetings for longer periods of time. How do you do that? We'll talk more about how to get that done.
How much, Tom,
So,
when organizations do this, can you just sort of actually go forward one? Can you just say, hey, we've decided that WhatsApp doesn't count, or we've decided that text messages don't apply to us? I mean, can you just sort of make a policy decision that they're not real, even if employees are actually using them?
Not in the way that you describe it. What you would do instead, if you say that these applications are prohibited, you can make that statement. But one other statement you want to make in your policy is that our company does not use X tool for business communications. Business communications may not take place in these areas. We had an organization that they use text messaging for all of anytime there was an accident, it was a manufacturing company. Anytime there was an accident, they would text message and with pictures and information about the accident, all incredibly relevant information. They wanted to put in their policy, we don't use text messaging for business communications. It's very hard to do that when they're using it for that particular purpose. So if you're going to try to make that decision and say, we're only going to use these platforms for business communication, you need to have a way to prevent that, we'll call it shadow IT, from them using things for unapproved reasons, or you need to be able to give them a way to do it that is at least easier or not as hard as what they're used to doing, as the process that they're used to having. So it's a challenge, but it's not effective to just say records don't exist in these places, because it's clear that we see that they're all over the place. They have the potential to be all over the place. So you can't just declare that. You have to have a policy that explains to them why that's important, but also gives them something that makes them okay with not going to a place that they might otherwise be more comfortable with using. So let's talk about what's in scope. When we say odds and ends, we're going to talk about all the places where business conversations and decisions are happening today. At the core are chat and collaboration tools, Teams or Slack, for a lot of people, Teams and Slack has replaced email as a primary work communication. We're going to talk about that ephemeral and encrypted messaging. They're growing in popularity. They're the hardest to govern, and that's where, as you can tell, that's where the regulators tend to be most concerned. That's where the fines are actually coming from right now. Recordings are a big category, and big, I mean that literally in terms of volume and size, because video calls are the new meetings. There's not many in-person meetings anymore. There's lots of video calls. By default, Zoom and Teams encourage recording, but most companies don't have a strategy for how long to keep them or whether even they should be kept. Important. Now, one thing we'll talk about is that those recordings also create transcripts. They can create notes and follow-up tasks. AI is playing a big role in that. That can actually be more useful as records than the recordings. They're searchable, they're lightweight, they're easier to classify, but do we want to keep them? We'll talk about that. And then we've got the brand new category, AI prompts and outputs. We weren't thinking about these even 2 to 3 years ago that we would need to include them, but they can have a lot of sensitive information in them. The challenge is figuring out whether they're part of the official record and when they're just a draft or a working document, because depending on what's part of the process you're in, they could be one of the others. We can't ignore email. It's not going away. I don't really want to call it an odds or an end because it's really a major player. We can't ignore it. It's useful as a benchmark because people already understand, to a certain extent, email retention rules. We can use it as the bridge to explain these new categories, but I'm going to focus mostly on these others. And as a case study, very quickly, one of the things we think you should be doing is mapping what types of tools your organization is using. Do these sound familiar to you? Are there others that are being used for communication that aren't on this list, that don't fall into one of these categories? We had a client where they had gone in to map everything, and they had done a survey, and their IT department had a very permissive application use tool that departments could bring things in as they wanted. They had to manage them themselves. They mapped over 40 active collaboration applications with data all over the place. WhatsApp groups, Zoom recordings and personal drives, unmanaged text messages communicating important business activities like agreeing to contracts and agreeing to deals. The mapping exercise really helped them understand the scope was a lot broader than they thought, and they needed to get a lot more control over it very quickly, or it was just going to continue to expand. Here's the question, and here's the question that Mark was asking earlier, which is, are these records? Are chats, messages, and recordings are they really records? And the answer is, they can be. And we look at the flow chart over there, the classic definition and the decision process for records still applies. Does the communication reflect a business activity? If no, it's not a record. If it's thank you very much or cake in the break room, like I like to say, it's not a record. But if it is, if it is a reflective business activity, then you go on and ask, is there a requirement to keep it either for a legal reason or a business reason? If the answer to that is no, again, it's a non-record. It might concern the business, but maybe it's a draft, maybe it's a convenience copy, maybe it's reference that we don't necessarily need to keep. But if it needs to be retained for some reason, it's a record, and it doesn't matter how it was created. The format that we're talking about, chat, video, transcript, AI output, all of that is irrelevant. If it's documenting a business action, it's a record. But just because something exists in Slack or Zoom or wherever doesn't automatically make it a record. So the opposite is also true. A lot of messages are just routine conversation or coordination. You know, part of the challenge here is that a lot of employees don't really have good training to understand what's a record and what's not. We see this a lot in organizations. They're like, what can we actually get rid of that we don't need to pay attention to? One company found entire chat threads in Teams. It was a life sciences company, and they found entire chat threads in Teams on clinical trial protocols, and no one realized these actually are part of the records. Once they identified this, now they also had regulated systems that they were using, but they were also having chats in Teams to do it. Once they identified it, they were able to make sure that those decisions were formally captured in their regulated systems, because those chat records aren't meant, those threads, weren't meant to be kept forever. So, you know, we look at that Slack chat, lunch at 12, not a record. Let's approve the vendor quote for $250, probably a record. The weekly check-in, Who needs that after a day or two? The Zoom recording of a contract negotiation meeting is pretty darn important. And as we'll talk later, anything that's a draft output is probably not a record. So it's going to depend on whether it's a record or not. But the answer is that there will be a lot of things in here that are records. So you need to understand how to account for them.
So Tom, it's interesting that the regulatory focus and the regulatory drivers around this, we sometimes think that when the regulators come in, they only look at traditional records. They only ask for paper or files, but that's not really the case, is it?
That is not the case. They will look for wherever they can find it. Now, part of this is, 4 or 5 years ago, they weren't thinking about asking for WhatsApp or Signal or Telegram. It wasn't on their radar. But now that they know that that traders and that other financial services people are using these ephemeral tools to make deals or to say things, that's one of the first things they ask for. So they're going to be asking for, as we've said, wherever it is and whatever it is, if you have it, we want it. And most retention requirements that we think about come from regulations, contracts, litigation expectations. They don't care what format the information happens to take. Over the last 2 years, they have fined financial firms literally billions with a B for failing to capture business messages on WhatsApp, not because the tool is forbidden, but because they didn't retain the records. Because if you had it, you should have kept it. Unfortunately, as we'll talk in a minute, WhatsApp and some of these others don't have those capabilities. So there are other ways to think about this. At the same time, privacy regulators, and on the right side of the screen, they want you to delete data as soon as you no longer have that legal or business need for it. Holding recordings or data indefinitely or chats, that violates that principle of data minimization. We want to make sure that we're keeping it the right time for the regulators on the one side, but for the privacy regulators, we're getting rid of what we don't need. That tension is between retention and deletion is really what we're dealing with today. In litigation, discovery obligations have expanded. Judges are now routinely asking about Teams or Slack information. They are used to it, and they are asking for it all the time. It's expected that you will preserve and produce it if it is relevant to a legal hold. And looking ahead, AI governance is coming fast. EU AI Act is already doing lots of things. There are some emerging US frameworks. We've been led to believe that the federal government will not have a policy. That seems to, I hear news stories questioning that constantly, but there are some entities that want to require organizations to keep records of training data or prompts or outputs, not forever, but enough to show accountability for the AI that they happen to be using. So all of these drivers are things you need to pay attention to, regardless of whether it's a record or not. These are the outer sources, outer groups that could put pressure on what you need to keep and how long you need to keep it.
So Tom, if a company's employees are using WhatsApp, even if the company did not formally approve them using it, they can be held responsible for the messages that the employees send on WhatsApp?
Correct. Yes, absolutely. I'll give if they learn about what's on WhatsApp, if they happen to learn what things are happening, then yes, absolutely. If any regulator determines that information is being kept in a place where business conversations were taking place, then the regulator is going to want to know about it. Like I said, it's billions with a B fines for keeping this information in a place that the businesses didn't know about, but they're liable for it.
So we have a question. Do you need to keep the information you qualify as a record in its original format? To what extent do we have to keep it in that, or to what extent can we save it in a different medium or different format?
We'll talk about that in a minute. And because that's important, especially with ephemeral messaging apps. You may need to keep it in a different format. You may need to keep it with a third-party vendor who now these vendors have popped up who can take care of that. But it will depend a little bit on the format and what you want to do with it. But I think the short answer is yes. You're not required to keep it in these places. You need to have it in a place, and you need to be able to capture it so that it has enough information about it to talk about to identify what the information is in it, and then keep it in that place where you can manage it according to your retention schedule. There's not a requirement, and frankly, the way that a lot of these applications work, you won't be able to keep a lot of that for the period of time you might want to keep it. So that's an excellent idea and something we'll talk about in just a little bit. All right, so what are the retention risks? This is where we have the too long versus too short question. Most organizations are going to fall into one of two traps. They either keep it forever, or they just delete inconsistently and too quickly. Or sometimes, if you're using a third-party tool, allowing information to be deleted too quickly because you may not have been aware how long that third-party tool was actually keeping the information. WhatsApp is a good example of that. The people who were using it didn't pay attention, or maybe they did pay attention and they didn't care. That was the reason why they were doing it. But over retention is creating some invisible cost. You're paying to store information that you're never going to use. In most cases, you're keeping personal data that could become liability under GDPR, under CCPA, other privacy laws. It's clogging up systems. We are seeing employees spending hours trying to figure out what's current in some of these areas. But then on the other hand, deleting too soon creates compliance gaps. Regulators expect for you to be able to document and reconstruct key business decisions or HR actions or financial transactions. Courts, we all have talked about the issue of spoliation. Courts are unforgiving about data that happened to be destroyed. If it should have been kept, it's presumed that that information would have been unfavorable to you if it were used in court. You know, that sweet spot, that blue spot in the middle, you like to talk about the Goldilocks zone, the right spot there is keeping it just long enough to meet your obligations and business needs and then deleting confidently. So there's a balance there. And that's where some of these retention principles come in. We're not going to guess. We're going to align with the legal requirements. We're going to align with our risk tolerance and what the business needs for the information. But we're going to adopt specific principles for each one of these that we can follow. All right, let's dive in. Let's talk about a couple of these. Let's start with chats, messages, and texts. For most organizations, chats and messages have replaced email as the primary way that people make decisions. It still happens in email, but we are seeing it happen more often, which means they can't be treated as disposable anymore. They're not just, and courts are recognizing that as well. They are requiring production of Slack and Teams content to be able to see that. The problem is, the line between casual and business use is fuzzy. We all have chat threads that start with weekend plans and they end up with a pricing decision. And we need to figure out how to keep all of that separate. And the good news is that Slack and Teams have actually made it straightforward to be able to separate casual and business use of messaging. When we think about both Teams and Slack, they think about communications in two ways. I'll start with Teams. Teams has the notion of the chat, which is just you and me, Mark, talking with each other, just asking questions, just a personal one-on-one conversation. That's the part that's individual. That's the ask about weekend plans part. Those messages don't need to be kept a long period of time. However, in an actual team, there are channels, and in those channels, there may be what Microsoft calls posts. So chats, temporary. Posts, though, need to be kept as long as you have that team set up. Is it set up for a project? Is it set up for initiative at your company? Is it set up for your marketing team to be able to handle the creation of marketing collateral? As long as that information is there, you may want to keep that communication for business purposes. So the retention, it needs to be different between chats and posts. And the good news is Microsoft lets you do that. In Slack, it's the terminology is different, but the principle is the same. Slack uses DMs for your chat messages, but they use the term messages for what Teams call posts. The bottom line here is that you have the ability to keep chats and DMs for short term, but keeping posts and messages for a longer term, whatever the purpose is of the project, of the team, of the channel, whatever it happens to be. Now, those texting services are a little bit different. And I hesitate to add them here because they really are significantly different from chats and messages in Slack and Teams, but I'll use them briefly. And I'm also hesitant to include WhatsApp here because WhatsApp belongs a little bit in the text category, but also in the ephemeral category because it doesn't keep everything forever. It allows you, the user, to keep everything forever, but it deletes text from its servers after a certain period of time. The challenge with text messages is, unless you have a mobile device management policy, or you have a bring your own device policy that allows you to have access to text messaging, it's hard to get access to a user phone. It's hard to get access to that information and command it. Even with organizations, and I'll talk in a little bit, even with organizations with user control phones, you may still have problems. The challenge with WhatsApp is there's no enterprise grade protection. It's designed for individuals. It lacks metadata. It has no centralized search. It doesn't retain deleted messages. It lacks enterprise administration controls. And that's why we saw in 2024 fines exceeding 600 million. FINRA is suspending individual brokers for messaging violations. Former Edward Jones broker was sending client documents via text message on their personal phone, bypassing the firm's retention policy. 77 FINRA member firms have been fined between 2021 and 2024 for failing to maintain off-channel communications. It's already happening. And if you're managing devices, you better do it right. So as I mentioned a minute ago, Deloitte Corporate Finance, they were managing, they had 99 firm-owned phones that they had actually set to disable or block iMessages. They said, we do not want to get iMessages because it creates risk. We are not able to, our archiving system can't capture Apple's encrypted messages. So we've just made the decision, we're not going to, you can't use iMessage on your phone. However, there was an iOS update that came down from Apple. It broke their blocking system, and the key employee that was managing the system left the company. There was no oversight. There was nobody paying attention to it. And so as a result, those 95 of those phones that were firm-owned, that were being controlled by the company, had 676,000 business communications that were completely unarchived, that were being allowed to be kept. So they were fined $200,000 by FINRA. Even when you do it, you need to make sure that you're doing it right. They had the right idea. They had the right policy. They were going to disable it, and they had the means to do it. You just got to keep up with that.
We have another question here, which is, we have employees who have to travel and work in China. In China, WeChat is the standard, and it's true. WeChat is not only messaging, it's payment. I mean, you basically can't operate in China without WeChat. Knowing that it's not a governed platform, what's the company to do?
Well, doesn't necessarily mean, and I'm not totally familiar with WeChat. I don't believe that WeChat has enterprise tools, but if they did, even if they don't, there are other third-party tools. We're going to talk about that in the next slide. Third-party tools that can archive them. This is one of those situations where business need actually trumps some of your other issues. You know it needs to be used. You know that these people have to have it. Finding the right way to archive that information is going to be an important activity to do. Whether there is a way, and there are certain more manual processes for archiving that are not ideal. In this case, maybe using a third-party tool. There are several third-party tools out there that can help with that. That would be the approach that you would need to go at, because you can't just prohibit it, especially for people who are working in China where WeChat is so common.
Well, the other issue of WeChat, of course, is that is it really protected, or who's really looking at those, and so what sensitive information you want to post.
That's a separate issue that you would need to be able to build up, hopefully, walls against or secure against as you are coming up with that policy. But my expectation would be that the third-party vendors who are able to archive it have tools and ideas and solutions for managing that. So let's talk about encrypted and ephemeral messaging. These apps here were designed for privacy. They're great for personal use. They are terrible for record keeping. So when you allow messages for business use, you are telling regulators, we have no record of what we did. For most companies, the right approach is either prohibit it or bring it under control. There is not a middle ground here, really. And so if you have to use a tool, you have to make sure that you are capturing those business decisions somewhere permanent. So, Signal is intentionally designed to make it difficult for third parties to monitor or access conversations. It's telling you straight up, We don't want you to manage this information. We want people to be able to be anonymous or have the comfort of confidentiality when they're doing this. There's no native archiving. It only stores messages on individual devices, and the ephemeral messaging is automatically deleting the content. However, in January 2024, Department of Justice, Federal Trade Commission have issued warnings that a failure to preserve ephemeral messaging is going to result in obstruction of justice charges. And it was not an empty threat. They specifically named Signal as one of the platforms that allows immediate and irretrievable destruction of communications. They actually provided guidance. They provided guidance to companies, and this guidance requires companies that adopt ephemeral messaging to generate a, quote, I'll read this, quote, thoughtful, advanced business justification statement showing how they weighed the risks and explaining their approach. Nothing different from what we're saying here today. You need to develop an approach. It needs to be thoughtful. It needs to be a business justification. Here's how we're doing it. Here are the risks. Here's our approach. Having that is what helps you with avoiding obstruction of justice charges if something happens like that. There are a number of enterprise tools that are able to sit between the user and the messaging app that capture messages in real time before they disappear. Smarsh is one of those tools. It's able to do that. There are a couple of other tools that have that capability for a number of ephemeral messaging apps. But I won't go through again the number of fines, civil litigation consequences, the duty to preserve ephemeral messaging, to preserve it when litigation is reasonably anticipated, is absolute. There's no question around that. So I've gone through, I think, all of the major fines and penalties. If your users are going to use ephemeral messaging, and probably you should find out if they are using it, since a lot of the financial services companies aren't aware of it, make sure you know whether it's being used or not and establish a policy if it is and you decide that it should be. Otherwise, find a way to prohibit it and make sure that you build enough content and consequence into your policy that if it is used, that you can hopefully avoid risk or avoid penalties if it turns out that somebody was violating it.
So Tom, if a company says, hey, we like ephemeral messaging because we hate the risk of, maybe they hate email, piling up, and they hate messages, and they go, well, the system deletes it, nothing we can do. And suppose there isn't a third-party app, can you say, well, nothing we could do about this? Could you still get in trouble for that?
No, you absolutely could get in trouble because that's what they're saying right now. That's what they're saying. Hey, these were apps we had nothing we could do. I will read that wording back. I will read that wording back to say that you must adopt thoughtful, advanced business justification statement. And quote, nothing we can do is there's nothing thoughtful or advanced or justified about that comment. The regulators are going to require that if you do it, you have to have a plan around dealing with it. All right, next up are meetings and recordings. Since 2020, recording meetings, that's the norm. Most recordings are temporary by design. They're supposed to be. They were never meant to be permanent records. And what's interesting is the average size of a 1-hour Teams recording is 400 megabytes. So just multiply that by how many meetings have you been in today already? Multiply that, you're dealing with a lot of information. What Microsoft found, they did a lot of internal research. They found that 95% of meeting recordings were not watched 60 days or more after the meeting. After 120 days, 99% were never watched again. So they implemented auto expiration for 120 days. Now, Microsoft says that's the default. The default is 120 days. We think that's a good idea. However, you have the ability to set that as low as 1 day and as high as never, which we think is not necessarily a good idea. Now, Zoom cloud recordings are automatically deleted after 180 days unless specific steps are taken to preserve them. That's usually a more manual effort, bringing them to another place off of the Zoom cloud. Zoom doesn't have quite the same granular power as Microsoft does in keeping information. Here's the thing with recordings. They're privacy sensitive. They're capturing faces. They have home environments. If minors happen to, if your kid walks by in a meeting, that's privacy, and you're creating risk there without value. That's why in a minute we'll talk about why transcripts might be a better response than the meeting recording itself. So the same principle should apply here. Informal meetings, let's keep them a short period of time. Longer period for trainings, for formal meetings, for important things that need to be kept, and let's keep them out of Zoom or Teams or wherever they happen to be recorded, let's put them in a place where we can manage them appropriately. What's interesting about this from a Teams standpoint is Teams recordings are actually stored in OneDrive accounts. Whoever organized the meeting, that file goes into their OneDrive, which is usually we think of as should be for their personal information. So there are some challenges with how Microsoft's architecture is constructed, but there are definitely ways to work around that and to think about it. And we definitely think that's the main thing you want to is figure out what do we need to keep and where should it go, and then everything else should be on a relatively short retention period.
Well, Tom, do all meetings need to be recorded? I'll give you an example. We have conversations with prospects and clients that we don't record.
And what we've been seeing is we've seen a number of companies actually develop policies on when recordings can occur. I think some of these policies tend to be a little draconian because they basically say, here are the 3 circumstances in which you can record a meeting, and they don't provide for the value of having a recording after a while. For example, if I have a brainstorming meeting with my team, I might want that video, or at a minimum, the transcript of that to be able to go back and analyze, see what the tasks are, the action items, get some information from it. So the recording is useful from that purpose. I think these policies that outright prohibit recordings without, unless you meet these 3 circumstances, I think there's a little strong, but I think that having some policy around meetings to say, in certain circumstances, if you're going to be talking, like you mentioned, Mark, when we talk with clients, we consider those to be confidential communications. We're not going to record them. You will have those types of those types of conversations too, that for whatever reason or not, you don't want to record, whether it's sensitive or whether it's just not an important meeting. Hop on a meeting to talk about something, doesn't need to be recorded. So setting some guidelines about what's a meeting that can be recorded and what cannot is a good idea, but really limiting people's ability to get the value out of the recording, I think, is also not the direction you want to go.
So this really is fundamentally a records retention discussion to some extent.
All of it is, yes. All right, and that's what's heading me to transcripts and notes. So instead of recordings, which take up a lot of space, some organizations are starting to keep transcripts instead. They can take up 400 megabytes of storage, and a transcript is taken up less than 100 kilobytes. It's very small. They're defensible. Let's say more defensible because they capture content. They're not capturing everything around it. So you take a lot of the privacy risk out of it by all of that. They're going to meet that business need while protecting the privacy. They make discovery and auditing a little bit easier. You can search them. You can redact them if necessary. You can export them, things that you can't do easily with audio or video files. You lose facial expressions or voice tone, which can become relevant in lawsuits or to regulators. As far as retention is concerned, Microsoft is pretty granular with this also, but it goes along with the meeting recordings. Usually when the meeting is deleted, the transcript is deleted as well. Zoom is more general. It's at that 180 days like usual, like its video recordings. What we usually recommend here is find a place to put these transcripts where they belong, because they are, in many cases, they will be records, or at least decide on the ones that constitute records. Same rule applies for transcripts as it does for videos. It might not be a meeting that was important enough to keep the transcript, but it might be one that you had some decisions made, or there was, like I said, brainstorming. So it's a good reference material. It doesn't necessarily, you're going to keep it a period of time, but it's good as reference material. But we would say move it out of Teams, put it into a dedicated record keeping system so you can manage it according to whatever type of record or reference material it happens to be. There are a couple issues that I forgot to mention here. Here's an issue to think about with transcripts, and it depends on the tool that you're using. There was an individual who attended a meeting, and it was being transcribed by, there's a third-party tool called otter.ai. You may or may not be familiar with it. It's a third-party transcription tool that's really good, and a lot of individuals use it. This person attended the meeting, but he came in the middle of the meeting. So parts of the meeting had occurred beforehand, parts of the meeting occurred after he left. He got the entire transcript. So he got access to confidential conversations he should never have heard. So keep that in mind. You may be having other issues around the transcripts depending on how you plan to share that, because they would get everything that's in it. There's no way to break that apart in any one of these tools. Also, and I don't know this for sure, but there is some warning from the legal community about the concept that having AI in the loop may violate attorney-client privilege, because it constitutes, if an AI tool is technically a third-party service provider, would that erode the lawyer-client privilege? Would that erode whatever privilege you're trying to maintain? Unclear. We've not seen any discussions about it. Probably just some good information and good things to consider. If you happen to have, this is one of those times, there may be conversations you don't want to have recorded or transcribed exactly for this issue. All right, let's talk about AI. Generative AI tools, ChatGPT, Copilot in Microsoft, Claude, they are quietly, or maybe not so quietly, created a totally brand new information category. And I would argue that it's probably multiplying faster than email or chat, or at least it has the potential to do that. What we're seeing, though, is that in businesses, fully 75% of people who use AI at work are actually bringing their own tools rather than relying on company provided solutions. They might still use those tools that the company is providing, but they're also, for their own purposes, to get their own work done, maybe using other tools that they're more comfortable with, that they may think do a better job. So, prompts and outputs now, they're part of business processes. They may be, how do I create this report? How do I create a draft of this document? How do I need to do some analysis? I need to create some code for IT. They may contain, and we've talked about this in past AI governance webinars, they may contain confidential information. They shouldn't necessarily, but they might. They might contain personal information about somebody. And then the question is, those outputs, they're being stored, they're being shared, they're being signed off as final work product. I'm not sure if you're familiar with the term AI slop. Employers now are starting to see a lot of purely generated by AI deliverables that just have not even been looked at by the employees, but they're being signed off as final work product and are probably records like that. But there's a lot of indecision right now on how long that information needs to be kept. Some prompts, they're like brainstorming notes. Let's delete them quickly. Some prompts, however, maybe they have ongoing value. We want to run this prompt every month to generate a specific report or get specific information. Maybe you treat those more like working documents. We're going to keep them for a short period of time. Or maybe we create a prompt library that we use as a reference library to keep the ones that happen to particularly valuable to us. But you're then, on the other side of it, that's the prompt side. Most are not records. Some are working files. On the output side, you've got to treat it just like any other record. If it documents a business decision, apply your existing schedule. Doesn't matter where the medium is, and you need to find some way to store it and regulate it and keep it the right way. As I mentioned earlier, regulators are also starting to, they want to be able to trace the training data. They want to understand the decision logic to make sure you're being accountable for the AI that you use, especially when it impacts customers or external people other than your employees. That means that some of that information may need to be retained as well. And
we got a
I think
question. I'm sorry, go on.
Oh, no, go ahead. I was just going to add real quick. The main thing here is you want to make sure that you're training your employees. That retention is useless if they don't know what to keep out of the AI tool in the first place. So making sure they know how to use it and what to use it. This is another place where training is important.
I was going to say, we've got a few more questions that have added up. We're going to wait a few minutes till we get to the end to answer those, but rest assured we haven't forgotten your questions. If you have other questions, be sure to post them.
All right, so you would think I would spend a lot of time on email, but I'm not going to spend a lot of time because we've had a lot of webinars where we talk about email. My question is, should email be included here? It's not really an odd or end. However, it is the file cabinet that everyone has. It's everyone's file cabinet of communications. but it includes records of all retention periods. It's going to include an invoice. It's going to include an HR document. It's probably going to include some contract information, all of which have different retention periods and may be kept in different places. A monolithic, let's just destroy all email after a year, after 2 years, even after 3 years, while that may sound good, and frankly, getting rid of email sooner than never getting rid of it at all is not a bad idea. It still has the potential to delete information that really needs to be kept longer than 3 years. So the strategy that you have with email is the same as the principles we've been talking about otherwise. A shorter period on your mailbox, temporary stuff, a temporary period of time, a short period of time for the stuff we really don't need. Let's keep those working files for a couple of years because we need to do our job. And then let's move the records to a place that can actually manage it, because email is a lousy place to manage information. So how do we make those retention decisions? First step, obviously, is the floor. Legal and regulatory requirements, these are the minimums. You can't go below those minimum requirements. Next, though, we look at the business value. How long does this information help you run your business, help keep the lights on, help you manage risk? Most of the time, the business needs to keep information much longer than the law requires that you keep it. That's why we take it next, because that usually extends whatever the legal requirement is to a much longer period of time. The next question, though, and this is really what this discussion is all about, is you have to test those rules against reality. Can the systems we use right now actually enforce this? Can users comply with these rules with the systems that we use without needing a doctorate in records management or something similar to that? You know, practicality is at the top because it's what determines what any of this will actually happen. And good defensible retention is balancing all three. You've got to have all three, or else you're going to be non-compliant, you're going to be inefficient, or you're going to be overwhelmed by a lot of information. So how do we think about this? And this is where my whole discussion really has been going up to, which is, don't ask, how long should we keep chat? How long should we keep email? How long should we keep this, and have different thoughts and different strategies for each one? The same principle applies to most all of these. We want to keep most of this for short term, depending on what the information happens to be. There might be some of these categories, posts and messages, generative AI tool, prompts, email, where having working versions of the information would be useful. But if there happen to be records, we're not going to keep that information any longer. We're going to put it in the right tool as long as we need it. So have the right archive tool, the right system of record. All of these principles are essentially the same no matter what the platform is. Think about, what's our short-term strategy? Do we have a working strategy? And where does long-term information need to go? If you have that consistent application, and I would also say, none of this goes in your retention schedule. If you put stuff in your retention schedule, we've seen schedules that just have the line email. Email is kept for this many years, and it confuses the heck out of employees because they don't understand, what am I supposed to do with that? This goes in a policy. I'm not saying don't put it somewhere, but it goes in your policy documentation. You might choose to have an ephemeral or other messaging policy. This might go in your records policy. I'm not going to tell you exactly how to do it, but there should be policy language. It doesn't go in your retention schedule because these are all formats and not actually content records. All right, as you are making these decisions, this really comes to who is responsible for it. And you've seen this slide before. We talk about this slide a lot because there's nothing about these decisions that doesn't implicate in some way most of the areas of your organization. Legal is clearly going to have some input on the legal requirements to keep them, the risks associated with keeping them too long or not keeping them at all in case of WhatsApp. Your compliance team likewise is going to want to make sure that whatever's being kept is following the regulatory rules so that you can produce them if you need to, or you're getting rid of them so you don't have to produce them. IT needs to know how to manage it. IT needs to know, what are we doing on our end to make sure that we're controlling it. And then it really starts, frankly, with the business, understanding how they use these tools. What are they using? You may be surprised. How are they using it? And making sure that any of the rules that you create don't negatively affect their ability to be productive, their ability to get things done. It may be that shutting down a WhatsApp channel makes you less less exposure to the regulators, but you may have just shut down an entire sales team from being able to actually get their job done. So work with them, figure out what's the compromise, what's the way that we can do this to be compliant and help them get their job done. So this is a team effort. Everybody is responsible for doing all of this work. You can't ignore anybody with these questions. And then when it comes to, we talk a lot about change management, and change management in this case is making those retention rules easy to follow. You want to automate as much as possible. We talk a lot about automation. There is much you can automate. There is some you can't. Do as much as possible. I like to say a lot, records management is not any employee's day job except for the people who are responsible for it. So don't try to make it harder for them. So automate it as much as possible so you don't have to worry about it. Publish and educate on the policy as much as possible. Let them know, here's our position on this, here are the rules, here are the expectations we have on for you, and here's what we'll be doing. We'll be deleting this information after this period of time. We'll expect you to delete this information after a certain period of time. Having that awareness, if you have rule followers, will go a long way. Creating cheat sheets, creating other tools, I think is super important to have them to be able to look at. Now, how long are we keeping chats? How long are we keeping text messages? What's the right answer for this? Having those resources will help them. If they don't know, and what we find with most clients is if they don't know what to do, they're going to default to a less ideal practice. My real quick case study here is the company that I mentioned earlier, the one that decided that they have lots of text messages about accidents that occur at their factory sites. They actually told me, well, we're going to prohibit it in our policy, but if it gets done, we're going to turn a blind eye to it. Mark's statement, what can we do? I had a real problem listening to that conversation because, prohibiting it by policy, not by practice, is absolutely the worst way to make these rules easy to follow. You want to make sure that everybody understands it, because if it turns out that it's in your policy, but yet there's thousands and thousands of text messages about things, you can end up in a world of hurt. And so sorry, I forgot this part was here. This used to be the rule, and this really needs to be the rule moving forward. If you're in doubt, ask, and provide enough materials to your employees to ask, or so they don't have to ask. So they have that information, but so they can feel free to ask if it's not clear. Here's your checklist to be finished, and I'm just really wrapping up here. You want a modern records policy, a policy that also includes these types of communications. Just by saying we're going to keep records for their retention period doesn't really address all of these the way that it needs to. You need an updated policy to be able to effectively cover that. Define your scope. You need to say, here are the tools that we use, and in these tools, these are records and these are not records, and here's how we shall deal with them. Apply those principles. Don't just randomly look at things and apply different approaches to everything. Apply the same set of principles no matter what the format is. Communicate to your people, communicate to IT so they know what to do. And then we mention this a lot. If you're not auditing, if you're not reviewing, it might be that 6 months from now, there's a whole new set of tools out there that nobody knew about that people start using. AI may have decided to generate its own other input that we had no idea was coming. So review it regularly to make sure that not only you're covering everything, but that people are following all the rules. I think that's all I've got, Mark.
Okay, next slide, please, Tom. So we've got a bunch of questions stacking up. Real briefly, I think most of you know us. We're the largest independent provider of strategic information governance consulting services. We develop record retention policies. We develop schedules. We help organizations figure out how to execute it. We can help you evaluate whether you've got the right technology. We can do the training. We've got a fairly full suite of services, and it's unlikely that we haven't encountered something in your environment that we haven't seen many other places. We do this for a lot of different organizations. All right, so Tom, next slide. I'm going to go through the first question. Actually, we already got that one. I understand the theory behind differentiating chats and posts in Teams, but I don't see people using one method for official company communications and a different for personal conversation. There is no way to police that, and people will use whatever is easiest. Knowing that a chat will be used for a business conversation doesn't mean that chat shouldn't be kept for a period of time. How do we separate these? We're never going to get this perfect, by the way.
We're not going to get it perfect, and you're always going to have some people who will use it one way or the other. But I think the method is to train them and say, in this instance, chat is not an appropriate place for business conversation, and because of that, we're going to be deleting your chat in 30 days or 60 days or 90 days, whatever that short period of time you have, which hopefully will transmit the message to them. If it's something you really want to go back and find, if you want to be able to say, what did I say in this chat? They will know that they need to say that over in a post in a team where it's being kept appropriately. That's the goal of the change management combined with the policy, is when they start to see things going away, we hope that their behavior alters, because they're going to go, oh my gosh, I've lost all those communications. Oh, but I can still have them over here because you're managing it right here. I just need to adapt my behavior to put it that way. Not going to be perfect. Not everybody's going to be willing to do it, but with good communications and training on how to do that, it's possible.
And again, the courts don't expect perfection. What they want are reasonable best practices. And so good faith efforts. And if you try it and you train and you address where you have that, you're actually going to go a long way. Okay, next question. We allow users to use approved chat and messaging apps, but state in our records management policy that informal communications, naming voicemails, chats, text call, and meeting recordings may not be used to document a record. If any decision is made, it needs to be documented through other methods. We then have a short retention for these apps, 90 days or less. Tom, feelings on that?
I think that's not bad. I would probably want to read it again and think about it more, but I think that's a good position to take. That you have set the standard. We do not use these. We expect you to put them in places. I would hope that you're backing that up with some education. Where do I put it? What should I do in which place? Make sure that instead of just having the policy, that you're also providing enough communication to them to let them know how to follow the policy. It might we want to, in case it's either too vague or you've kind of put all of those things all in together, and some of them may have different ways that you're dealing with them. So maybe as long as you're making sure that you're communicating with them, maybe have a couple of frequently asked questions or job aids that can help them determine between which of those types of messaging tools how to deal with it. That might also be helpful.
I should say we're at the top of the hour. We're going to keep on answering your questions, and if you have to drop off, the recording will be available. So if we want to do that, but we're going to stay on if you have other questions out there. Just a quick note, we also do a virtual in-house seminar. This is just to team members in your organization, in your company. We present many of the best practices we're talking about here, not a sales pitch or a marketing pitch, just pure content. It's a good way to get other stakeholders in the group involved, get people understanding this. And so if you're interested, email us at Contoral. We're happy to be able to present that. We can even offer CLE credit for one state for this. And so very, very popular. We've been doing a lot of these, but it's a good way to try to get everybody on the same page. Next slide, please. Okay, Tom, we have another comment here. Retention is so hard to apply when your company is global. True. I mean, do all these strategies apply to global, or what do we do for global?
That's probably a webinar in itself to talk about, because there's a lot of considerations that you need to have. Is it appropriate to, the questions that I would have were do you apply your IT services on a regional basis? Do you have different IT groups depending on different parts of the globe? Do they all follow the same types of policies? How are you structured first? Because I think that would guide the discussion on how to apply this. You're right. It's hard. It's not impossible to do, but you have to come up with a strategy based on how you're structured and whether it makes sense to try to implement this and also we have to think about the different applications too. The different, as we mentioned, WeChat in China may need completely different, if you're operating in China, completely different ways to deal with it than other tools in other countries. So there's a lot of questions that come into that I agree with you. It's difficult, but I think that understanding more about your structure will help to determine the best way to create a strategy in that.
We work with a lot of global organizations. It's not easy, but it is doable. Just flipping back and forth, we have a couple webinars. November, we have the great debate. Can Microsoft 365 be used as your records repository? Can we use it for records? Can we use it for everything? What shouldn't go in Microsoft 365? You know, many of us grew up with Microsoft 365 not being a real records management tool, is it? And also we have in December, how to hire for information governance. Okay, Tom, another question. How does the media-based retention periods work for when the content and the format is for something that needs to be retained longer, especially to public records? And so are we allowed to move it to a different medium? And at what point should we, because we have to save it for a very long time?
I mean, I think that unless there are regulatory requirements that prohibit you from storing things in certain areas, I don't see, or if you are unable to, if you, one, need to preserve metadata and moving it to another area would prevent you from doing that metadata, I think those are some of the questions you need to ask. But otherwise, there usually isn't an issue about where they're kept. Like I have mentioned with the WhatsApp, because they are disappearing frequently, the SEC doesn't care where you put them, only that you keep them. And so there was actually recommendations that I saw that recommended that users take screenshots of every WhatsApp message that they have and store it somewhere. I think that is a terrible practice, but that's something that I saw being recommended somewhere. So I think the answer is, as long as you find, here is our system of record to store that information long term, and we have everything that we need here that's part of it, I think that should be defensible. For some of these systems, if you need to be able to get timestamps and other metadata, maybe using one of those third-party archives is the best way to do it, because they should be able to preserve that information. But it really depends on the media and what your specific requirements. When it's around public records, I'm not aware of specific metadata requirements around public records, except for maybe date and timestamps and things like that. But I think that as long as you're comfortable with what the rules are, you should be able to put it into a different system.
And there's just a handful of exceptions. Sometimes, for example, X-rays, other things like that, moving that to a different medium, you really have to be careful with that. But those tend to be very, very industry specific in certain cases. Okay, we have additional content here. We have white papers available. Happy to share these white papers. Either email us or go to our website. Happy to be able to do that. And next slide, please. I think I've answered all the questions. If not, call me on it. We also have a number of other recorded webinars. We've touched on some of those topics. These are also available complimentary on our website. Go take a look at them. And I think that pretty well. We also have some blogs and articles out there on you know, you need to, how to approach AI, and can we use machine learning, and how do we cut costs? Other interesting content on there. And next slide. And we have our summer school that we did. Go take a look at our website. These are recorded sessions that are available now for Microsoft 365. And finally, I'm going to mention we have upcoming in a few weeks our peer exchange. And so we get senior stakeholders together from within a specific industry. We work with a lot of different industries, and not us talking at all. It's actually just our clients and invited guests speaking amongst themselves. Sometimes it just gets good to get together with their peers. And so we organize these 60-minute, we do this once a quarter. Email of us if you're interested at info@comptroll.com. And next one, we're going to be at ACC next week. If you're going to be at the ACC annual meeting, Association of Corporate Counsel, stop on by. We'd love to see you. Say hello. And next slide. I think that's it. So we're definitely out over time because we had lots of questions, but happy to be able to do that. If we didn't answer your question, or you want to do a follow-up, email Tom or email me. Happy. And by the way, if you just want to jump on the phone with us for 15 or 20 minutes, don't worry. We're not going to charge you for it. We'll happy to do that. Or if you want to discuss your particulars, easy for us to do, and happy to be informal about it. Okay. Thank you, Tom, for an excellent discussion. Really, really good information. Appreciate that. And we wish you success as you start addressing your odds and ends. Take care.
Thanks, everybody.